Glassman versus Pro Health, number 105.
Good afternoon, Judge.
Good afternoon, counsel. Would you like any rebuttal time?
4 minutes, please, Judge.
4 minutes, sure. Go ahead.
May it please the Court, my name is Evan Krinick, and along with my partner, Stu Bodoff, we represent the appellant, Pro Health here. There's been a lot in the news over the last year about health care reform, and a lot of health care reform deals with the desire to provide quality health care at an affordable cost. And while this case was pending, I saw this New York Times article on the front page. It says, "Hospital shows a way to save. Doctors get salaries, not fees." And what the article talks about is a hospital in Cooperstown that decided to pay all their doctors a straight salary in order to disincentivize them.
But counsel, you have an ambulatory center here, right? Isn't it a little different than a hospital in terms of its makeup, in terms of your charter, your mandate? Aren't you narrowly limited in terms of what you could do and not do? You think you're the same as a big hospital or medical center?
We're a hospital that can't have patients stay more than 24 hours. Under the Public Health Law, Article 2801, we are defined as a hospital.
Yeah, but aren't you regulated in a different way? And if you do have all this off-site activity, isn't it likely to negatively impact what you do in that center and a reason why you received your license?
Well, the Department of Health is the regulatory body that would regulate whether we're complying with our operating certificate or not. And the Department of Health has taken...
Yeah, but you're a narrower, again, protocol than you do in a big hospital, don't you? You are the equivalent of a large hospital?
We are a hospital in every way other than the fact that our patients cannot stay more than 24 hours.
And you're totally analogous, the two situations.
Well, they're different.
You're no more limited in what you could do than a hospital.
Let me say there are differences in aspects of what a general hospital can do and what an ambulatory surgery center can do.
Even given what you had to go through to get your ambulatory surgical center.
A hospital needs to go through the same type of procedure to get their operating certificate, which is also site-specific. So when hospitals...
So we're not protecting the public at all by, if we were to limit you to not being allowed to do these fee-splitting arrangements.
Let me just explain it this way. I would say that Dr. Glassman is a licensed physician in the state of New York. He's our employee, and he is permitted to practice medicine anywhere in the state of New York. And I don't think anybody would dispute that. We're an ambulatory surgery center. We're entitled in our facility to perform certain types of procedures.
What about outside your facility?
Right. Well, Dr. Glassman has the authority to go outside our facility.
Right, but what about you?
We work through our employees. A facility doesn't practice medicine. A facility gets a license to run its facility.
But your license to do whatever you do is limited to the site.
There's no question that what the facility is operating as a site. We would violate that license, for example, if in that site we did a transplant, because we're not allowed to do that type of procedure in that facility.
But when you look to your incorporating documents into the regs, doesn't it specifically define a location, a site?
Yes, but we're...
With an address?
Yes, absolutely, and we're not violating that. We are providing services in that facility consistent with our operating certificate. What our employee is doing, I mean, this comes down to the money, but before we get to the money, let's understand that patient care is not at issue here. Every patient is being treated by a licensed physician.
But let's say that your employee or the employees and the work that they do off-site is 10 times more the money-producing entity than the center is itself, that there's all kinds of things going on off-site. Is that in any way at variance with your license and how that is regulated?
That's for the Department of Health, who regulates and...
So it doesn't matter if it's dwarfed, if what you do in the on-site, even though, as Judge Separak says, your license is for a specific place, a specific address, that work could be dwarfed by what your employees do off-site, and it wouldn't matter.
It wouldn't matter in this sense. It certainly matters in the Department of Health, which regulates Article 28 facilities, would have the ability to come in and look at that as an administrative matter.
So you could do whatever you want unless they stop you.
No, but we're not doing anything we want.
Well,
we're having our employees are practicing medicine.
In that case, of course, your employee might decide he wanted to quit if you're taking a piece of this huge amount of money he's earning off-site.
We're not taking a piece of anything. We're taking all of it. It's our money. Under the common law, when an employee earns money during the course of his employment, it belongs to the employer.
Well, is he in the course of his employment when he's practicing medicine off-site?
Yes, he is generating fees. He's getting paid a salary for full-time work. And when he's doing that work either on-site or off-site, it's part of his full-time work. And we're paying him a salary for that. So is he going to give us back the salary?
He's not allowed to walk into some off-site office and say, well, maybe let's put it this way: if some doctor called up ProHealth and said, send over one of your people, and you said, okay, I'm sending Glassman, and Glassman is going to be ProHealth for these purposes and give anesthetic in someone else's office. That's not allowed, is it?
Sure it is. Why is that? That is certain.
What does it
That's
mean?
what hospitals do.
What does it mean to say that you aren't allowed to provide services off-site?
We are running, within our facility, there are certain things we can and can't do. But if a nursing home calls up a hospital and says, we need a doctor here today to tend to all of our nursing home patients, that hospital, that employee physician of that hospital can go to that nursing home and tend to those patients. No one would say they couldn't do that. They have the authority under their license to practice medicine.
I understand the doctor can do it. I guess, isn't there a distinction between the doctor doing it and maybe sharing his fee with the hospital and the hospital actually doing it?
But the question is, why does a sharing of the fee between off-site, this is rhetorical, I'm not asking you to answer it. The question is, why is the difference between an on-site and off-site on the money make a difference? If these are authorized doctors performing authorized services, then the money, the fact that they have an agreement, we're paying you a salary.
Well, let me ask you about a statutory prohibition. What about Education Law 6530 and 6531, which says that, the physicians can only engage in fee sharing if they're associated in a professional corporation or a partnership? This isn't a professional corporation, right?
No, it's not. It's an employer-employee relationship. And when Dr. Glassman performs
are these
services,
statutes relevant to this situation?
I think fee splitting is an artificial issue here. I do, and let me tell you why. If Dr. Glassman performs services on our site, anesthesia, a bill gets sent to a health insurer. The surgeon performs services on our site. A bill gets sent to the health insurer. We send in a facility fee. That money comes in. That goes to the facility. Nobody would say that's a fee splitting or a fee sharing arrangement because that's the money that our employees earn. The location of those services doesn't change that. Moving the location of those services off-site doesn't turn something that's not a fee split into a fee split.
Well, then why did we have the McShane case? Why was it such a question as to whether medical colleges?
Well, I think McShane exactly makes that point. I think my comment about the procedure here is based on this Court's ruling in McShane.
But doesn't McShane say that we're not going to read the statute literally, that we're making an exception for this kind of thing because, as I said, because it's not the evil that the statute was aimed at? And don't you have to bring yourself within that exception?
Well, I think the foundation of McShane, the answer is yes, but the foundation of McShane was that a hospital could do this, so we're going to allow a medical college to do it too. And the Court had before it in McShane a Department of Education opinion which said exactly that hospitals and medical colleges can take the money earned by their employees in their private practice. So the foundation of McShane, why you extended it to medical colleges, was because a hospital could do it. And hospitals today do it regularly, and all the amicus briefs before this Court tell you that the hospitals are doing this day in and day out. They are outsourcing their physicians and receiving the fees. They are sending their physicians into the community to practice medicine.
Does it make a difference whether the hospital sends the physician out into the community, as you say, or whether the doctor himself or herself moonlights?
Moonlighting would be different, because moonlighting, as we would understand the word, would be something outside the work hours.
Right.
It would be, I have a day off tomorrow, I want to go moonlight in the emergency room. That would be something
Would those
separate.
fees be subject to maybe yours? No?
No, that would be outside. But when you
So
come in...
your rationale is grounded on the fact that you have a full-time contract of employment with
Yeah, but
this
the common law-
anesthesiologist, and you're paying $350,000 a year or whatever it is,
Right,
and as
we're-
part of that compensation package, you're looking for whatever fees that individual earns
Right.
to come back to the employer?
That's the contract we made. I think that's what common law would require. If an employee earns income during his employment, it belongs to the employer. This Court has held the employee holds that money in constructive trust. Again, the focus here is patient care.
If any of these anesthesiologists, because I take it there's more than a half dozen here, right? If they had their own private practices, would your contract wrap in their private practices?
Well, again, I don't know what private practice would necessarily mean. If they're employed by us
Well,
as a
they've got
full-time employee...
they've got their own office.
But once they
Say
come
they're
to...
radiologists, maybe that's a little bit easier. They have a private practice and they're reading x-rays for people that haven't gotten any services from your ambulatory center.
But if they're a full-time employee of us, it's mutually exclusive for them to have a private practice. If they're our full-time employee,
Are
they're
they
our full-time
precluded,
employee.
or-
If they're a part-time employee and they're doing something on the side in a private practice, that's not this situation. We pay full-time salary for a full-time employee.
Mr. Krennic?
Yes.
In all of these cases where Dr. Glassman and the others were off-site doing this stuff, if they get sued, do you defend them?
We would be vicariously responsible as their employer
Does that
and
happen?
have malpractice insurance to cover it. That's part of the contract we made.
Has that happened?
Not that I'm aware of.
Just a practical, how much money are we talking about here? What is the amount of the fees that you say he should have shared with you that he didn't?
It's $500,000 fees, which he began taking within a few weeks after he began
So that
his employment.
would this wipe out his damage award, or virtually wipe it out, or give
Well-
it balance in your favor?
I think it would have to, it would affect the damage award, but also it would establish a breach of the contract, which would not enable Dr. Glassman to establish that we breached the contract.
I know your red light's on, but I have one last question. If you were hiring him full-time and paying a fairly decent salary for full-time, how did he have the time to earn all these fees?
Well, this
Did
was-
you send him to these other locations?
This was the plan from the beginning that Dr. Glassman brought to ProHealth, was that I could build up an in-house anesthesia department that we could then send out into the community.
Did you send that? Don't answer the judge's question. Did you send him out, or did he make these other arrangements, and he just has to give you back part of the fee?
He was running the anesthesia department at our facility. So he was,
So when he makes the arrangement for himself, he's making it for you.
he's doing it as
in
our
your-
employee. So
Okay.
he's doing it, we're doing it, he's doing it as our employee. And the plan was, I'm going to build an anesthesia department. We're going to service the patients in the center, and we're going to go out into the
And
community.
he's doing these other services where? At area hospitals?
Physicians, private physicians' offices, on procedures that are appropriate in a private physician's offices. They would call up ProHealth, they call
And
up.
you were aware he was doing this?
Yeah, that was the original plan. I think there's some dispute in trial as to whether, when we were aware, how much we were aware, when we were aware we weren't getting the money, but this was not, this was the plan going in.
Okay, counsel, you'll have rebuttal time.
Okay,
Thanks.
thank you.
May it please the Court, my name is David Wirtz. I'm with Barbara Grossman. We represent Dr.
Counsel,
Glassman.
was that your client's understanding that that was the plan from the beginning?
That's actually a firm finding of fact in the case, Your Honor, is that this was done not at the sufferance of ProHealth, but at the direction of ProHealth. Part of his job was to go out and do in private physicians' offices what ProHealth, ASC, was prohibited.
So why shouldn't they get the fee?
Because they were
Or part of it.
They were prohibited from doing by.
So you
He agreed to this, though, right? He was aware of this when he signed the contract.
No, ma'am. The firm finding of fact in the case is that he did not know that he was not permitted to engage in
No, I'm
this.
not talking about the legal aspect. I'm saying he was aware that ProHealth was expecting him to convey the fees that he earned
That's correct.
to ProHealth, correct?
Yes,
I
ma'am.
mean, that's not something that came as a surprise.
That's correct.
You're saying that when he was working off-site, he's working for himself, not for ProHealth.
I'm not saying that at all. The finding of fact in this case is that he was working for ProHealth. That's what Judge Warshawski
So
found.
you're finding he made, your argument is, yes, he knew, yes, he made that deal, but later on it turns out that he finds out it's illegal, so he doesn't have to give them the money. Why aren't they entitled to the money? Is this against public policy, or is it just illegal? What's the rationale that you get the windfall as opposed to them getting the money that they contracted for?
Well, it's two things. One, it's
You
unlawful.
do get a windfall, right, if
No.
under your theory?
Actually, no, Your Honor. There's not a windfall.
Why not?
Well, here's what happened. And these are all firm findings of fact in the
They
case.
were paying you an annual salary.
That's correct, $350,000. And the other piece of the compensation was this NAR pool, which was all of the money generated by these anesthesiologists, both in and outside.
And there's no, we understand that, I think we understand that they stiffed you on that pool and they owe you money.
That's correct.
But why don't you owe them the share of the fees off-site that you said you'd give them?
Because they were prohibited, we were prohibited as their employee from engaging in that activity.
So because so that was an illegal activity, you're saying?
That's correct.
And therefore you keep all the money?
The parties are basically under the law, the parties, same as a gambling contract, the parties are pretty much left where they sit.
And why was it prohibited?
It was prohibited because they could not do 755.1 of the Department of Health's regulations prohibited ProHealth from providing services in private.
Shouldn't
But
you
weren't
give back
doing
the
it under your
350?
license?
Well, here's how it balances out, Your Honor, and this is what Judge Warshawski found. He said basically what he was doing was balancing the equities. All of the money that was generated and put into the NAR pool was not distributed. It was over $7 million. The amount of money, this $500,000 is frankly not in the record. All the money that's in the record is $115,000 of money generated by this off-site service. So they kept the $7 million, and Dr. Cooper told these anesthesiologists, I don't care what your contract says, I'm keeping that money. And if you don't like it, if you don't renegotiate your contracts, you're going to be fired.
Right.
And he did. Judge Warshawski left that money, all of which they generated with their labor at ProHealth. So it's really different from this idea.
Wait, he didn't say you could recover your share of the pool?
He recovered his share of the pool, but it's not exactly like it was a windfall. He did the work. It's not like-
But why? There was a deal.
Correct.
That he would be an anesthesiologist working on-site and off-site, and the fees would be shared. How come you get your share of the pool for the work he did on-site, and he doesn't? But you don't have to pay their share of for the work you did off-site?
Because the requirement to turn over the share was unlawful.
So why do we sever that? Why don't we say, okay, it's an illegal contract, nobody gets anything? We'll throw the parties back in the water where we found them.
Well, the other pieces of the contract, this piece of the illegal portion of the contract was in fact severed.
What justifies severing it in a situation like that?
Well, it's not a situation like in the Creameries case or these other malum prohibitum cases where they got the milk and kept the money. This is. I think malum prohibitum and severance are different things. And severability are different things. If it's malum prohibitum, you just enforce the contract. But if it's an illegal contract, then you have to worry about whether you separate the illegal from the illegal parts. That's what I'm asking about. Correct. And the person who cannot, Dr. Glassman cannot turn over that money because he's forbidden to do so by the regulation.
Okay, so why isn't the answer to that, okay, Dr. Glassman, you don't turn it over, but I'm not going to make them turn over anything to you either but it's all one deal. As a matter of fact, give back your salary.
And it's
part of the same deal.
There's no breach of his fiduciary duty, and he was fired without cause, and that money was earned and kept by.
How common are these arrangements?
We have no idea, honestly.
Well, do you know that they're not common?
We don't know. The record doesn't tell us, which is actually a warning in our view. It comes from the Hospitals Association as well, which is we don't really know. There's no charter except the McShane Medical School charter in this record. The only certificate or operating certificate that you have before you on this 6,000-page record is the one we have from ProHealth, which forbids this activity.
They say they're no different than a hospital or a medical center. Do you agree with that?
No, Your Honor.
Why are they different?
They appear in the initial section 2801 of the law as a hospital, as does a dental dispensary, any other a dentist, any other number of things fall within this rubric of hospital. But the larger, if you get more specific as you go down the chain, so to say, and we also have a definition of a general hospital. We have definitions saying an ASC is not a general hospital. So it's fully briefed actually in the Hospitals Association amicus in the case. Yes, Your
I hate to ask this because this was a motion to amend. Which should be freely given, et cetera. I mean, why wouldn't we allow the amendment and let you go back and do another 6,000 pages of testimony, I suppose? But some of the questions are troubling. I know when I was county attorney in Erie County, we had the Erie County Medical Center, and there were all kinds of deals with the doctors. I mean, they had private offices in the hospital. They saw private patients there. If they got sued, that's why I asked if they got sued under private patients, they had their own coverage. There was things if they taught that was handled a different way. Now, the Erie County Medical Center is a big place, but I could see where a small place, I mean, if we find that this place here, I don't know anything about it, but if we said your anesthesiologist can't leave the building, what do we do? What does that do to the community? What does that do to health there? And before you answer that, I mean, you got to think we got 62 counties. We've got, as you mentioned, dental dispensaries, et cetera. Are we saying to each and every one of them that you can't let your employees outside of the building?
No, Your Honor. What we're saying is you can't let them work outside of the scope of what the state has authorized you to do.
Well, that's what I mean. I thought that's what you're saying.
Isn't the same thing in the way?
I don't know that it is. No, Your Honor. I mean,
Why is it the
What's
same
the
thing here?
resolution? What are you saying, that all the doctors have to work only part-time
well, there's
at these off-site centers and earn 1/3 or 1/2 of what the salary here was, and then they do what they want to do under their license the rest of the time?
Well, of course,
you
they
can't have a full-time?
You can have a
position?
full-time person working for your hospital, doing everything that your hospital is authorized to do.
But he has to do it there.
No. If there's a geographic limitation in the charter of the hospital, the operating certificate for the hospital, then yes. That's what we have here. We have a geographic limitation and we have a function limitation.
Why was what happened in McShane allowed?
In McShane actually was a reflection of the fact that actually what happened in McShane is the Albany Medical College needed a hospital. So they created a hospital next door so that they would have a place, of course, for their doctors and their students to treat actual patients. And according to the record in McShane, all 13 medical schools in the state did precisely that.
But what they did was literally prohibited by the fee-sharing rules, wasn't it?
That's correct, Your Honor. And
So McShane stands for the proposition that we aren't going to enforce those rules absolutely strictly where there's not a policy justification for it.
so long as, and here's a subtle distinction that appears in my opponent's brief, so long as it's consistent with the charter, and the Albany Medical School charter authorized it to promote medical science and instruction.
Okay, I can't get either side to look at it this way, but suppose we did look at it this way. Suppose what Dr. Glassman did off-site was not for pro-health. He was working for himself. And then there would be no problem with the violation of the charter. The problem would be that he agreed to share his fees.
Which he's not permitted to do.
Which he's not permitted to do, but the guys in Albany against McShane weren't permitted to do it either. Why shouldn't we say, look, this is a licensed health care entity that was his employer. It's not within the fee-sharing prohibition.
For two reasons. One is there was a very strong public policy reason to make that exception, which was it would have been pretty hard on medical schools, and that's what was in the record and proved in the record in that case. We don't have that.
But in general, isn't it consistent with public policy for a perfectly reputable licensed health care institution to say to its doctors, you can practice on the side, but we share with you? What's wrong with that? How does that threaten the standards of the profession?
Our legislature and our regulators have said it's not permitted.
Well, they said it in literal terms in McShane too, and we said they can't have meant that because there's no reason.
Correct. And in McShane, this court found that there was a very powerful public policy reason to be served, which was the fostering of medical care and the teaching of doctors. Here, it's all about the money. There's no underlying public policy reason to make sure
Both said that. It's all about the money.
It's all about the money, Your Honor. That's right. This case is not about any form of public policy. And if you look...
Well, maybe, I suppose, you could say, I don't know, like everybody else have been listening to a lot about health care the last year, but I suppose you could say it's more expensive to provide some of these services in a hospital. Maybe you want to encourage ambulatory care centers of this sort.
You absolutely do. But the countervailing policy, which is why ambulatory surgery centers can't provide services that can be provided in a private doctor's office, is because it's more expensive to do it in an ambulatory surgery center than in a private doctor's office. And that's where...
You think it helps or hurts them that they have people with that arrangement? Where they're off-site and they're able to provide, is this helpful to them? Is this something that benefits them?
I'm sorry, who is them, Your Honor?
Pro-health.
Does it benefit them?
Yeah. Does it hurt within the context of their charter? You could argue whether they're supposed to be doing these things on site, and that's what they're supposed to be concentrating their efforts on. By having this kind of ability to let their people do this work, does that hurt what goes on site? Do you advocate that, or it really is neutral in
The
terms?
only thing on the record with regard to that, as best I can, Your Honor, is that they stopped doing it before this case arose, before they fired Dr. Glassman. They cut out the outside practice altogether, which of course goes to the severability issue if it was the guts of...
If they didn't have the NAR pool, or however you want to pronounce the pool that the anesthesiologists were putting the fees in, I suppose they might have had to pay these individuals less in salary.
Well, actually, if they didn't have
I
the
mean,
NAR
were they
pool, they
looking
would
at
have
that pool,
probably...
were they looking at that pool as something to offset the expense of the salaries of the anesthesiologists?
The NAR pool money, a good portion of it was taken for the administration of the center.
Right.
That's correct.
It went into the revenues of the centers. So to
That's
some
correct.
extent, it offset the salaries that were being
Actually, the
paid.
permitted activity very substantially contributed. It was over $7 million during the relevant period. So yes, that's correct, Your Honor.
But didn't both sides see the whole deal as a single economic deal? The hospital gets this, Dr. Glassman gets this, and part of what the hospital gets is a piece of Dr. Glassman's fees. And if that's the case, why shouldn't we either uphold the whole arrangement or none of it?
Because the part of the arrangement that Judge Warshawski enforced was lawful. The part that he severed and refused to enforce was unlawful.
Why was it not malum prohibitum?
Because, for a couple of reasons. One, there is a public health and safety issue, and I'm not able to speculate entirely about what would cause a regulator to do one thing or another. But let's say, for example, that I create a shell ASC. I don't have any intention of providing the service in the Bronx, and my intention is to create it, get my approval, and then send my doctors out where they can earn more money and be more lucrative for me altogether. Under the theory here offered, that could happen. It's not a problem, so long as it was permitted by the employment agreement.
But wouldn't the other opposite happen too? I mean, if you've got an eleemosynary institution that are surviving on the split fee arrangement and they can't do it, they don't exist.
That could be a case that comes before you, Your Honor, but that's not this case. We don't have anything in the record that would tell us that happened. The only thing in this record...
No, but we know there's a lot of small community hospitals that if they didn't allow their physicians to have private practices would never be able to afford the salaries to keep certain specialties in their hospitals.
Absolutely. And there's nothing, we're not arguing that you can't have a private practice. Someone mentioned moonlighting. If I'm a physician and I'm working for a hospital full-time, what I generate goes to the hospital. That's Woodbury. That's not even, we don't even get the fee splitting there. But if I'm not working for the hospital and I'm out there in my private practice or I'm going to a nursing home or whatever I'm doing...
You're saying the hospital can get all of it or the doctor can get all of it, but they can't split 50-50?
They cannot send the money to someone who is not authorized to provide that service. That's right, Your Honor. So if I'm moonlighting on my time...
What sense does it make to say you can have it 100% either way but can't split the difference?
I'm not sure how to answer that except to say that the split is prohibited. So that it's the only answer I'm afraid that I can give you. They weren't permitted to engage in this activity.
Isn't
so
that a
they
definition
cannot,
of the expression malum prohibitum? It's bad because it's prohibited?
It's bad. Here's the thing. Malum prohibitum requires you to use it essentially as a sword. It's like where I have the milk and I have the money, and you had to be licensed, so I get the milk and the money, and you're out. And we don't have that here at all. What happened is this, Dr. Cooper said, I'm not going to give you your money for the service that you provided, and it's too bad.
Okay, counsel. Thank you.
Thank you, Your Honor.
Mr. Krennick, the bills that went out that we're talking about, these fee-splitting bills, were they on pro-health? Were they pro-health bills?
Well, they were supposed to be pro-health bills. That's what the contract provides. We were supposed to bill and we were supposed to collect, but Dr. Glassman stuck his hand in that till and sent out his own bills and collected the money and now refuses to give it to us, which is why there's this argument that he's got the money, but it's not his money.
But if they had been pro-health bills, then this fee-splitting issue would go away.
It's artificial, which is what I think it's an artificial issue, because under the contract, he can't create a fee-splitting issue by sticking his hand where he's not supposed to put his hand and take the money out of the expected route of payment.
Wasn't there evidence, or didn't the court find that your client knew that he was, that it was going through Dr. Glassman, or not directly to the...
He knew or should have known. The court did find that. I think what the overview I hear from this whole discussion is that the Department of Health is the entity here that needs to get involved and regulate these entities to find out exactly what it is they can and can't do. And if anything, their lack of action just speaks to the fact that this court may need to resolve the legality of the issue, because I think even if you assume it's illegal, which clearly we don't think it is, it's still enforceable. And that's a critical point, and for these parties, that's the critical issue. Is this contract enforceable? And under Charlotte Boys, against J.R. Weller,
How do we distinguish, if we say it's illegal but enforceable, how do we distinguish between fee-splitting agreements that are enforceable and those that aren't?
Well, I don't think this is the fee-splitting issue. I think, as Justice Piggott pointed out, this is an artificial fee-splitting issue. This is an authority issue. Does our regulation, does some regulation, which has yet been cited, allow us to collect this money? That's malum prohibitum. It's nothing evil about that. That's simply a question of regulations. And if it's malum prohibitum, just like the education law provision in Charlotte Boys, where they didn't allow a licensed engineer to sign a contract, but this court nonetheless enforced that contract. Why? Because the actual work was done by a licensed person subject to regulatory oversight. Well, so too here. The licensed doctor performed all the work. There's no unlicensed entity in this scenario at all.
No, but your ambulatory center couldn't have opened a satellite center 4 blocks away.
Correct. Without approval from the Department of
So
Health.
why is it that you can send your employee 4 blocks away
He's
to
permitted.
provide a service?
Because the employee has all the authority he needs.
But you're the one who just said you want to bill as if it's pro-health.
We're collecting the
But
money.
how can you bill for a service that you are not permitted by the Department of Health to provide at that location?
But the answer is, maybe it's unsatisfactory, but the answer is that our employee has got the license to do it. He's got the authority to provide that service. So patient care is not endangered.
Why isn't it his fee that he's sharing with you?
Because he's our employee and we're paying him a salary for full-time work.
I'm trying to understand how you can have it both ways.
Well-
He's doing it under his license, but it's your fee.
Yes, he's our employee. But my point is that even if you go beyond that, the contract remains enforceable. Even if, because a licensed person is providing the service. And if you go through all the factors in Rosasco and Charlevoix and all the enforceability malum prohibitum cases, we really fit within each one of those factors. This is a windfall to Dr. Glassman. This is malum prohibitum. It's done by licensed people only.
If we agree with you, what is the result? What happens next?
I think the judgment should be reversed.
Okay, I got that far.
I want to make sure I got that out.
And
And a remand to Supreme Court, because I think once the judgment is...
Let Supreme Court figure out what happens next is your answer.
Well, I think it's a little, with the 1 minute on, I'm not going to explain all that I think is going to happen next, but I think the judgment has to be reversed. And we didn't get past the pleading stage here. This was a motion to amend to assert counterclaims to make this.
Well, you had a trial.
Had a trial on the affirmative case. There were no trial on the counterclaims, which were not allowed to be amended to put into evidence here. So even if this court rules or doesn't reach the issue...
The bottom line is there has to be some degree of you're not saying throw out the whole trial, but you are saying you have to reopen it and let you put in your proof.
Yes, we'd have to have the amendment. But may I just finish my thought, Judge Lemon?
One thought. Go ahead.
My point is, even if the court doesn't decide the legality issue or illegality issue, which really is a Department of Health issue, which they've not weighed in on, the case should still be reversed on either the enforceability grounds or the severability grounds, both of which provide independent grounds for reversal.
Okay. Thank you.